Welcome back to Artificially Informed, the podcast series that takes an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. As always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and meticulously review and edit all of the output. In today's episode 3, we continue our exploration of Part 1, Section A, Scope of the Sunshine Law, specifically focusing on what entities are covered by the Sunshine Law. Application of the Sunshine Law to... We'll be navigating pages 6 through 20 of your manual. Our discussion will include ex officio board members, federal entities, the governor and cabinet, individual board members, the judiciary, the legislature, married couples serving on the same board, private organizations, and finally, staff members or public officials also serving as members of a public board. Let's pick up where we left off, beginning with ex officio board members on page 6. Segment 1, ex officio board members, federal entities, governor and cabinet. Ex officio board members, as noted on page 6, are subject to the Sunshine Law regardless of whether they serve in a voting or non-voting capacity. Attorney General Opinion 05-18 confirms this. Informal opinion to Ardaman, June 24, 2021, specifically states that a mayor serving as a non-voting ex officio member of municipal boards is subject to the Sunshine Law, and see Linares versus District School Board of Pasco County, number 17-00230, Florida 6th Circuit Court, January 10, 2018, further reinforcing that the Sunshine Law applies equally to all advisory committee members, even non-voting staff. Next, let's consider federal entities found on page 7. Federal agencies, meaning agencies created under federal law and operating within Florida, typically do not fall under the purview of the state Sunshine Law. Attorney General Opinion 71-191. For example, meetings of a federally created council are not subject to Section 286.011 Florida statutes, as per Attorney General Opinion 84-16. However, if a board is created pursuant to state law, the Sunshine Law applies even if federal officials serve on that board. See Informal Opinion to Markham, September 10, 1996, which found a technical oversight committee established by state agencies as part of a settlement agreement in a federal lawsuit to be subject to the Sunshine Law. Similarly, Informal Opinion to Green, December 11, 1998, concluded that a tri-state river commission established pursuant to state and federal law is subject to the Sunshine Law. Also, see Informal Opinion to Knox, January 6, 2005, which states that the St. Johns River Alliance Incorporated, a nonprofit corporation formed to help carry out the Federal American Heritage Rivers Initiative, is subject to Section 286.011 Florida statutes requirements. And Roscoe versus Abreu, number 03-California-18. 3.3, Florida Second Circuit Court, August 6, 2004, found a committee composed of state, local, and federal agencies subject to the Sunshine Law due to its state creation and responsibility for evaluating corridors for a parkway expansion. Compare Brown versus Denton, 152 Southern 3rd 8, Florida 1st District Court of Appeal, 2014, which held that closed-door federal mediation sessions changing city employee pension benefits constituted collective bargaining negotiations that should have been held in the sunshine. Moving to the governor and cabinet on page 7, Article 4, Section 4 of the Florida Constitution establishes the cabinet. The governor and cabinet serve as the head of certain executive branch departments and also have responsibilities stemming directly from the Constitution, such as clemency under Article 4, Section 8, Florida Constitution. The Sunshine Law does not apply to the powers of the governor and cabinet that derive directly from the Constitution. Therefore, when exercising clemency powers, they are not subject to Section 286.011, Florida statutes, see in readvisory. Opinion of the Governor, 334 Southern 2nd, 561, Florida 1976, which clarified that clemency power is constitutionally prescribed and not subject to legislative intervention. However, Section 286.011 Florida statutes does apply to functions of the governor and cabinet that are statutory responsibilities rather than duties arising solely under the Constitution. For instance, when they act as a board created by the legislature or with statutorily defined powers, such as the Board of Trustees of the Internal Improvement Trust Fund or the Florida Department of Law Enforcement, they are subject to the Sunshine Law. In such cases, they are exercising powers subject to the dominion and control of the legislature. Furthermore, Article 1, Section 24, Florida Constitution, requires that meetings of any collegial public body of the executive branch of state government be open and noticed to the public. Exceptions to this constitutional right of access are only those exempted by the legislature or specifically closed by the Constitution. Also, Article 3, Section 4, Paragraph E, Florida Constitution, mandates that all prearranged gatherings between the governor, the president of the Senate, or the Speaker of the House of Representatives, the purpose of which is to agree upon formal legislative action that will be taken at a subsequent time, or at which formal legislative action is taken regarding pending legislation or amendments, shall be reasonably open to the public. Segment 2, Individual Board Members and the Judiciary. Let's transition to individual board members, discussed starting on page 8. Section 2, 86.011 Florida statutes generally applies to public boards and commissions as collegial bodies and to meetings of 2 or more members discussing matters that will foreseeably come before the board. Therefore, it does not ordinarily apply to an individual member of a public board or commission or to public officials who are not board members. See National Council of Compensation Insurance v. Fee, 219 Southern 3rd, 172-179 Florida 1st District Court of Appeal, 2017, and Mitchell v. School Board of Leon County, 335 Southern 2nd, 354, Florida 1st District Court of Appeal, 1976. Informal opinion to Dilliner, January 5, 1990, also states that the Sunshine Law is not normally applicable to a town council member meeting with private citizens. However, Jennings versus Dade County, 589 Southern 2nd, 1337, Florida 3rd District Court of Appeal, 1991, review denied, 598 Southern 2nd, 75, Florida 1992, noted that ex parte communications in quasi-judicial proceedings raise a presumption of prejudice. Section 2, 86.0115 Florida statutes was enacted in response to the Jennings case, specifically addressing access to local public officials in quasi-judicial proceedings. The manual emphasizes that the Sunshine Law is to be construed so as to frustrate all evasive devices, as stated in Town of Palm Beach versus Gradison, 296 Southern 2nd, 473, 477, Florida, 1974. This principle means the law can be implicated by a meeting between a board member and a non-board member acting as a liaison. See Attorney General Opinion 89-39, which notes that aides to county commissioners are not subject to the Sunshine Law unless delegated decision-making functions, acting as liaisons, or acting in place of the board. For an individual board member meeting with a member of another public board, on page 8, the Sunshine Law typically does not apply unless one or more of the individuals has been delegated the authority to act on behalf of their respective board. Roe versus Pinellas Sports Authority, 461 Southern 2nd, 72, Florida, 1984, Accord Attorney General Opinion 84-16, and Informal Opinion to McClash, April 29, 1992. News Press Publishing Company, Incorporated versus Lee County, Florida, 570, Southern 2nd, 1325, Florida 2nd District Court of Appeal, 1990, also found the Sunshine Law inapplicable to mediation attended by individual members of different boards where no final settlement negotiations could occur. Therefore, an individual city council member may meet privately with an individual member of a municipal planning and zoning board to discuss a recommendation, provided no decision-making authority is delegated and neither acts as a liaison. Attorney General Opinion 87-34, Accord Attorney General Opinions 99-55 and 97-52. Regarding a mayor meeting with an individual city commissioner or city council member on page 9. If the mayor is a member of the council or can break tie votes, such meetings discussing foreseeable council matters are subject to the Sunshine Law. Attorney General Opinion 83-70. Informal opinion to Ardaman, June 24, 2021, supports this for non-voting mayoral council members. However, if the mayor is not a council member, has no vote even in a tie, and only has veto power, private meetings with an individual council member are permissible, provided the mayor does not act as a liaison and no authority is delegated. Attorney General Opinions 90-26 and 85-36. Informal opinion to Cassidy, April 7, 2005 notes, a mayor can meet with a council member to discuss recommendations for appointees. Contrast this with City of Sunrise versus News and Sun Sentinel Company, 542 Southern 2nd, 1354, Florida 4th District Court of Appeal, 1989, where the mayor disciplining employees under the city charter was not subject to Section 286.011 Florida statutes. Concerning the use of non-board members or staff to act as liaisons or to conduct a de facto meeting of the board, on page 9, individual board members can generally consult staff for factual information and advice without triggering the Sunshine Law. Sarasota Citizens for Responsible Government versus City of Sarasota, 48 Southern 3rd, 755-764, Florida, 2010. Attorney General Opinion 81-42 confirms that a council member discussing views with a reporter is fine as long as the reporter is not an intermediary to circumvent the law. Compare State versus Dorworth, number 14-Mike-5841, Florida Orange County Court, October 21, 2014, affirmed number 14-Alpha Papa-48, Florida, 9th Circuit Court, August 19, 2015, which dismissed a charge against a lobbyist for relaying information, finding the legislature did not intend the statute to apply to private citizens. However, to frustrate all evasive devices, the Sunshine Law is implicated by a meeting where a non-board member acts as a liaison for board members. Transparency for Florida, Incorporated versus City of Port St. Lucy, 240 Southern 3rd, 780, Florida 4th District Court of Appeal, 2018, cited Attorney General Opinions 96-35 and 75-59. Paris versus State, 359, Southern 3rd, 1178, Florida 4th District Court of Appeal, 2023, warned about private meetings through surrogates. Thus, a city manager should avoid polling commissioners on specific matters destined for a public meeting to share that information with the board. Attorney General Opinion 89-23, Informal Opinion to Gorin, October 28, 2009, cautions against commissioners using staff as a conduit for de facto meetings. Compare Sarasota Citizens for Responsible Government versus City of Sarasota, Supra, at 765, where informational briefings with staff not communicating commissioners' views to others did not violate the Sunshine Law. Additionally, Blackford versus School Board of Orange County, 375 Southern 2nd, 578 Florida 5th District Court of Appeal, 1979, found a series of successive private meetings between the superintendent and individual school board members to avoid public discussion of redistricting to be a de facto meeting in violation of Section 286.011 Florida statutes. See also Transparency for Florida Incorporated versus City of Port St. Lucy, 240 Southern 3rd, 780 Florida 4th District Court of Appeal, 2018, telephone calls between city attorney and individual council members to discuss city manager termination could be sunshine law violation. Compare State versus Foster, 12 Florida Law, Weekly Supplement 1, 194 Alpha, Florida Broward County Court, September 26, 2005, which found a breakfast where commissioners individually questioned a sheriff who acted as a common facilitator to be a sunshine law violation. Similarly, Citizens for a Better Royal Palm Beach Incorporated versus Village of Royal Palm Beach, number Charlie Lima, 9114-417 Alpha Alpha, Florida 15th Circuit Court, May 14, 1992, invalidated a contract where a city manager's individual meetings with council members led to a substantial change in terms without a public meeting. See also Sentinel Communications Company versus School Board of Osceola County, number California, Ray 92-0045, Florida 9th Circuit Court, April 3, 1992, which found private meetings between a superintendent and individual school board members to discuss administrative structure should have been public. Attorney General Opinion 23-04 also states that University Presidential Search Committee members cannot use a search firm for anonymous candidate ranking to influence future meetings. Attorney General Opinion 93-90 advises against individual board members compiling CEO evaluations for private discussion with the CEO. However, not all staff decisions require board approval. Florida Parole and Probation Commission versus Thomas, 364 Southern 2nd, 480, Florida 1st District Court of Appeal, 1978, found a legal counsel's decision to appeal after discussions with individual board members not subject to the Sunshine Law. Informal opinion to Biasco, July 2, 1997, allows administrative officers to contact individual board members for views if the officer has authority to act. Regarding delegation of authority to individual to act on behalf of the board, on page 11, a public body cannot evade the Sunshine Law by delegating public business to an alter ego. IDS Properties Incorporated versus Town of Palm Beach, 279 Southern 2nd, 353, 359, Florida 4th District Court of Appeal, 1973, certified question answered, sub nom, Town of Palm Beach versus Gradison, 296 Southern 2nd, 473, Florida, 1974. News Press Publishing Company, Incorporated versus Carlson, 410 Southern 2nd, 546, 547 to 548, Florida 2nd District Court of Appeal, 1982, stated that delegated de facto authority to act on behalf of public officials subjects those individuals to the Sunshine Law. In News Press Publishing Company versus Lee County, 570 Southern 2nd, 1325, Florida 2nd District Court of Appeal, 1990, mediation sessions with individual board members but limited authority were found not subject to the Sunshine Law. Compare Broward County versus Connor, 660 Southern 2nd, 288-290, Florida 4th District Court of Appeal, 1995, review denied, 669 Southern 2nd, 250, Florida 1996, which held a settlement agreement required formal action at an open public meeting. Lee County versus Pierpont, 693 Southern 2nd, 994, Florida 2nd District Court of Appeal, 1997, affirmed, 710 Southern 2nd, 958, Florida 1998, found no Sunshine Law violation when a county attorney was authorized to make settlement offers up to a certain percentage above appraised value. Attorney General Opinion 74-294 advises that a single board member delegated lease negotiation authority is subject to the Sunshine Law and cannot negotiate in secret. Accord Attorney General Opinion 84-54. Similarly, Attorney General Opinion 75-41 and 74-84 state that a hearing or investigatory proceeding conducted by an individual board member or a board member and executive director on behalf of the entire board must be in the sunshine. Attorney General Opinion 10-15 confirms a special magistrate exercising delegated decision-making authority of a value adjustment board is subject to the Sunshine Law. However, if a board member is authorized only to gather information or act as a fact finder, the Sunshine Law does not apply. Attorney General Opinions 95-06, 93-78, and 90-17 compare State Department of Management Services versus Lewis, 653 Southern 2nd, 467, Florida 1st District Court of Appeal, 1995, where a board chair's order of reconsideration to provide notice of a hearing did not violate the Sunshine Law. More recently, National Council on Compensation Insurance versus Fee, 219 Southern 3rd, 172, 179, Florida 1st District Court of Appeal, 2017, ruled that a statute requiring a committee of an insurance rating organization to comply with the Sunshine Law did not apply to a single actuary performing the function. The court noted committee means a subordinate group, not a single person. Furthermore, if an individual, not the board, has statutory authority to act, discussions are not subject to Section 286.011 Florida statutes. City of Sunrise versus News and Sun Sentinel Company, 542 Southern 2nd, 1354, Florida 4th District Court of Appeal, 1989, found a mayor disciplining employees under the city charter was not subject to Section 286.011 Florida statutes because he was not a board. Compare Attorney General Opinion 13-14, which found that a city attorney drafting an employment contract consistent with a public commission meeting's approval did not require another commission meeting. Next, we move to the judiciary, starting on page 12. Due to separation of powers, the judiciary is generally not an agency for purposes of Section 286.011 Florida statutes. Attorney General Opinion 83-97, access to judicial proceedings typically falls under other constitutional guarantees like the Sixth Amendment, U.S. Constitution, or the First Amendment, U.S. Constitution. However, a circuit conflict committee created by the legislature to approve attorneys for conflict cases is subject to the Sunshine Law, even if a chief judge is a member, because these committees are legislatively created. Attorney General Opinion 83-97. Also, Canny versus Board of Public Instruction of Alachua County, 278 Southern 2nd, 260 Florida, 1973, states that the Sunshine Law applies to quasi-judicial functions of boards. For criminal proceedings on page 12, courts have inherent power to control their proceedings. Miami Herald Publishing Company versus Lewis, 426 Southern 2nd, 1 Florida, 1982, and State ex Rel, Miami Herald Publishing Company versus McIntosh, 340, Southern 2nd, 904 Florida, 1976, established a three-pronged test for closing criminal proceedings to balance open government with a defendant's right to a fair trial. The factors are: 1. Closure is necessary to prevent a serious threat to justice. 2. No alternatives exist to protect fair trial rights other than venue change. And 3. Closure is effective and no broader than necessary. See also Morris Publishing Group, Limited Liability Company versus State, 136 Southern 3rd, 770, 779 Florida, 1st District Court of Appeal, 2014, and Miami Herald Media Company versus State, 218 Southern 3rd, 460, Florida 3rd District Court of Appeal, 2017. For civil proceedings on page 13, stressing the strong presumption of public access, Barron versus Florida Freedom Newspapers, Incorporated, 531 Southern 2nd, 113, Florida 1988, outlined 5 factors for courts considering closure. 1. Strong presumption of openness. 2. Public and media have standing to challenge closure, with the burden on the party seeking closure. 3. Closure only when necessary to comply with public policy, Constitution, statutes, rules, case law, protect trade secrets, a compelling governmental interest, obtain evidence, avoid substantial injury to innocent third parties, or avoid substantial injury by disclosure of matters protected by common law or privacy rights, not generally inherent in the proceeding type. 4. If no reasonable alternative, use the least restrictive closure. And 5. Presumption of openness continues through appellate review. See also amendments to the Florida Family Law Rules of Procedure, 723 Southern 2nd, 208, 209, Florida, 1998, and Lake v. State, 193 Southern 3rd, 932, 934, Florida, 4th District Court of Appeal, 2016. Regarding depositions, on page 13, while court proceedings are public, the general public and press typically do not have a First Amendment right to attend discovery depositions. Palm Beach Newspapers, Incorporated versus Burke, 504 Southern 2nd, 378, 380, Florida, 1987, cert, denied, 108 Supreme Court, 346, 1987. Accord Post Newsweek Stations, Florida, Incorporated versus State, 510 Southern 2nd, 896, Florida, 1987, and SCY Funeral Services of Florida, Incorporated versus Light, 811 Southern 2nd, 796, Florida 4th District Court of Appeal, 2002. Compare Lewis versus State, 958 Southern 2nd, 1027 Florida, 5th District Court of Appeal, 2007, which states that unfiled depositions from ongoing criminal prosecutions are subject to disclosure after the case is final. For Florida bar grievance proceedings, on page 14, these are private and not subject to the Sunshine Law, as confirmed in Florida Bar versus Committee, 916 Southern 2nd, 741, 744 to 745, Florida 2005. The court reiterated that the legislature cannot control purely a judicial function. Concerning grand juries, on page 14, grand jury proceedings are secret under Section 905.24 Florida statutes and thus not subject to Section 286.011 Florida statutes. See Clean v. State, 52 Southern 2nd, 117, 120, Florida 1950, and in Rigetti, 427 Southern 2nd, 380, 383, Florida 4th District Court of Appeal, 1983. Grand juries are considered a coordinate branch of the judiciary. State ex relo. Christian v. Rudd, 302 Southern 2nd, 821, 828, Florida 1st District Court of Appeal, 1974. Other cases also support the secrecy of grand jury proceedings. Finally, for Judicial Nominating Commission's Judicial Qualifications Commission, on page 14, judicial nominating commissions are generally not subject to the Sunshine Law. Canner versus Frumkes, 353 Southern 2nd, 196, Florida 3rd District Court of Appeal, 1977. However, Article 5, Section 11, Paragraph D, Florida Constitution, requires that their proceedings and records, except deliberations, are open to the public. Deliberation-related records, like vote sheets, remain confidential. Informal opinion to Russell, August 2, 1991. Justice Coalition versus the 1st District Court of Appeal, Judicial Nominating Commission, 823 Southern 2nd, 185, 192, Florida, 1st District Court of Appeal, 2002. Workers' compensation judicial nominating commissions created by statute are subject to Section 286.011, Florida statutes, Attorney General Opinion 90-76. Judicial Qualifications Commission proceedings are confidential until probable cause is found and formal charges are filed. Regarding mediation proceedings, on page 14, For court-ordered mediation, Sections 44.102, Subsection 1 and 44.103, Subsection 1, Florida statutes, require these to be conducted per Supreme Court rules. Rule 10.360, Paragraph A, Florida rules. For certified and court-appointed mediators, mandates. Confidentiality unless disclosure is required or permitted by law or agreed to by all parties. See Everglades Law Center, Incorporated versus South Florida Water Management District, 290 Southern 3rd, 123, Florida 4th District Court of Appeal, 2019, on redacting mediation communications from public litigation session transcripts. In News Press Publishing Company, Incorporated versus Lee County, Florida, 570 Southern 2nd, 1325. Florida 2nd District Court of Appeal, 1990, mediation with limited representative authority did not require public access. Compare Brown versus Denton, 152 Southern 3rd, 8, Florida 1st District Court of Appeal, 2014, which found closed federal mediation sessions on pension benefits violated the Sunshine Law. O'Connell versus Board of Trustees, 1 Florida Law Weekly Supplement, 285, Florida 7th Circuit Court, February 9, 1993, noted that mediation for public agencies is subject to the Sunshine Law and no more than one collegial body member should attend. Rule 1.720, Paragraph D, Florida Rules of Civil Procedure, and Rule 9.720, Paragraph A, Florida Rules of Appellate Procedure, clarify representation in mediation for public entities. For other mediation proceedings, on page 15, mediation meetings, under sections 164.101 through 164.1061, Florida statutes, the Florida Governmental Conflict Resolution Act involving officials with negotiation authority are subject to the Sunshine Law. Informal opinion to McQuagg's February 13, 2002. Attorney General Opinion 06-03 states that a closed attorney-client session cannot discuss settlement negotiations for ongoing mediation not in litigation. Finally, concerning statutes providing for closed court proceedings on page 15, certain court proceedings may be closed by Florida statutes. Adoption, hearings are closed. Section 63.162, subsection 1, Florida statutes. In readoption of HYT 458 Southern 2nd, 1127, Florida 1984, upheld this statute. Dependency. Adjudicatory hearings are public unless a court order closes them for public interest or child welfare. Section 39.507, subsection 2, Florida statutes, Mayor versus State, 523 Southern 2nd, 1171, Florida 2nd District Court of Appeal, review dismissed, 529 Southern 2nd, 694, Florida 1988, found a former version of this statute constitutional. Guardian advocate appointments, hearings are confidential. Section 39.827, subsection 4, Florida statutes. HIV test results, court proceedings seeking access to HIV test results are in camera unless the tested person agrees to an open hearing or public interest requires it. Section 3, 181.004, subsection 2, paragraph E, subsection 9, Florida statutes. Pregnancy termination notice waiver. Hearings for a minor seeking waiver are confidential and closed. Section 390.01114, subsection 6, paragraph F, Florida statutes. Termination of parental rights. Hearings are confidential and closed. Section 39.809, subsection 4, Florida statutes. Natural parents of J.B. versus Florida Department of Children and Family Services, 780 Southern 2nd, 6, Florida 2001, upheld its constitutionality. J.I. versus Department of Children and Families, 922 Southern 2nd, 405, Florida 4th District Court of Appeal, 2006, found the Sunshine Law inapplicable to permanency staffing meetings for termination of parental rights petitions. Compare Stanfield versus Florida Department of Children and Families, 698 Southern 2nd, 321 Florida, 3rd District Court of Appeal, 1997, where a court could not prohibit public discussion of independently obtained knowledge. Victim and witness testimony in certain circumstances. Section 918.16, subsection 1, Florida statutes allows clearing the courtroom for minors under 16 or intellectually disabled persons testifying about sex offenses except for listed individuals. Section 918.16, subsection 2, Florida statutes mandates clearing the courtroom upon victim request for sex offense testimony, regardless of age, except for listed individuals. Compare Pritchett versus State, 566 Southern 2nd, 6. Florida 2nd District Court of Appeal, review denied, 570 Southern 2nd, 1306, Florida, 1990, which found violation of public trial right if closure findings not made. Accord Kovaleski versus State, 854 Southern 2nd, 282, Florida 4th District Court of Appeal, cause dismissed, 860 Southern 2nd, 978, Florida, 2003. Segment 3, Legislature, married couple, serving on board, private organizations, staff member also serving on board. Now let's turn to the legislature, discussed on page 16. Article 1, Section 24, Florida Constitution, requires that legislative meetings be open and noticed as provided in Article 3, Section 4, Paragraph E, Florida Constitution, unless exempted by the legislature or specifically closed by the Constitution. Article 3, Section 4, Paragraph C, Florida Constitution, also requires recorded votes on final passage of legislation and upon request on other questions. Pursuant to Article 3, Section 4, Paragraph E, Florida Constitution, legislative committee and subcommittee meetings and joint conference committee meetings must be open and noticed. And it also requires that all prearranged gathering between more than 2 members of the legislature or between the governor, the president of the Senate, or the Speaker of the House of Representatives, the purpose of which is to agree upon formal legislative action that will be taken at a subsequent time, or at which formal legislative action is taken regarding pending legislation or amendments, shall be reasonably open to the public. These open meetings are subject to order and decorum. Each House's rules define and control this section, including admission to the floor and possible closure of committee meetings for security or witness protection. And each House is the sole judge of interpretation. Senate rules are at flsenate.gov and House rules at myfloridahouse.gov. For a married couple serving on the same board, on page 17, there is no per se sunshine law violation as long as they do not discuss board business outside of compliant meetings. Attorney General Opinion 89-06. Let's discuss private organizations starting on page 17. The Attorney General's office has recognized that private organizations are generally not subject to the Sunshine Law unless created by a public entity, delegated a governmental function, or integral to a public entity's decision-making process. Attorney General Opinion 07-27. However, the Sunshine Law does apply to private entities created by law or public agencies and to private entities providing services to and acting on behalf of governmental agencies in their public duties. For private entities created pursuant to law or by public agencies, on page 17, the Supreme Court stated that the open meeting concept extends to every board or commission of the state or of any county or political subdivision over which the legislature has dominion or control. City of Miami Beach versus Burns, 245 Southern 2nd, 3840 Florida, 1971. Thus, if a private entity is created by law or by a public agency to perform a public function, the Sunshine Law applies. See National Council on Compensation Insurance versus Fee, 219 Southern 3rd, 172-180, Florida 1st District Court of Appeal, 2017, and Attorney General Opinion 00-08. Examples include the Pace Property Finance Authority, Incorporated, per Attorney General Opinion 94-34, and the South Florida Fair and Palm Beach County Expositions, Incorporated, per Attorney General Opinion 95-17. Attorney General Opinion 04-44 stated a nonprofit managing corrections work programs was subject to the Sunshine Law. Other examples include the Florida High School Athletic Association, per Attorney General Opinion 98-42, a city redevelopment agency nonprofit, per Attorney General Opinion 97-17, and insurance trust funds from collective bargaining agreements, per Attorney General Opinion 16-01 and 98-01. Also, Section 20.41, Subsection 6 and Subsection 8, Florida statutes, states that area agencies on aging are subject to the Public Records Act and public meetings requirements when considering contracts requiring fund expenditure. For private entities providing services to public agencies, on page 18, a private corporation providing compensated services to a public agency is not automatically subject to the Sunshine Law unless governmental functions are delegated to it. McCoy Restaurants, Incorporated versus City of Orlando, 392 Southern 2nd, 252, Florida, 1980. See also Attorney General Opinions 98-47 and 80-45, an informal opinion to Gates and Coley, December 17, 2009. However, the Sunshine Law can apply if a public entity delegates the performance of its public purpose to a private entity. Memorial Hospital, West Volusia, Incorporated versus News Journal Corporation, 729 Southern 2nd, 373, 382 to 383, Florida, 1999. Accord National Council on Compensation Insurance versus Fee, 219 Southern 3rd, 172, 180, Florida 1st District Court of Appeal, 2017, and Hollifield versus Big Bend Cares, Incorporated, 326 Southern 3rd, 739, Florida 1st District Court of Appeal, 2021. Kiesler versus Community Maritime Park Associates, Incorporated, 32 Southern 3rd, 659, 660, Florida 1st District Court of Appeal, 2010, review denied, 47 Southern 3rd, 1289, Florida, 2010, found a not-for-profit overseeing waterfront development subject to the Sunshine Law. The Attorney General's Office also found the following subject to the Sunshine Law: Family Services Coalition, Incorporated, Attorney General Opinion 00-03. Astronauts Memorial Foundation, Attorney General Opinion 96-43. A nonprofit designated by a county for cultural affairs, Attorney General Opinion 98-49. A nonprofit operating a public golf course, Attorney General Opinion 02-53. A downtown redevelopment task force acting in place of the City Commission, Attorney General Opinion 85-55, and a private nonprofit offering to recodify zoning, Attorney General Opinion 83-95. Informal opinion to Bedell, December 28, 2005, advises a nonprofit operating a city-funded theater to comply with the Sunshine Law. More recently, National Council on Compensation Insurance versus Fee, 219 Southern 3rd, 172, 180, Florida 1st District Court of Appeal, 2017, found a national insurance rating organization not subject to the Sunshine Law because the state agency retained approval authority and did not delegate an agency function required to be in the sunshine. Hollifield versus Big Bend Cares, Incorporated, 326 Southern 3rd, 739, Florida 1st District Court of Appeal, 2021, likewise found a private entity providing services to a state agency not subject to the Sunshine Law as no public purpose was delegated. For the application of the Sunshine Law to specific private entities, on page 18, this includes direct support organizations. On page 19, Attorney General Opinion 05-27 found a direct support nonprofit corporation subject to the Sunshine Law. See also Informal Opinion to Chumento, June 27, 1990, Attorney General Opinions 92-53 and 11-01, the legislature has exempted portions of meetings for some direct support organizations, for example, university direct support organizations discussing research funding, Section 1004.28, subsection 5, paragraph C, Florida statutes, and Department of Veterans Affairs direct support organizations discussing anonymous donors, Section 292.055, subsection 9, Florida statutes. Economic development organizations, on page 19, Attorney General Opinions 10-30 and 10-44 concluded the Sunshine Law applies when a public agency's economic development authority is delegated. Compare informal opinion to Gates and Coley, December 17, 2009, which found open government laws inapplicable to a private economic development corporation without delegation of governmental function. Economic Development Commission versus Ellis, 178 Southern 3rd, 118, 123, Florida 5th District Court of Appeal, 2015, stated the totality of factors test should be used, not the delegation of function test, if there isn't a clear, compelling, complete delegation of a governmental function. Refer to pages 61 to 64 for more on these tests. Homeowners associations, on page 19, the Sunshine Law generally does not apply to homeowners association board meetings. Informal opinion to Fasano, June 7, 1996. Other statutes govern their records and meetings, e.g., Section 720.303, subsection 2, Florida statutes. However, Attorney General Opinion 99-53 found an architectural review committee of a homeowners association subject to the Sunshine Law if it must approve county building permit applications. Attorney General Opinion 07-44 found a property owners association subject to open government laws when acting on behalf of a municipal services taxing unit. Political parties. On page 20, meetings of political parties are not subject to Section 286.011 Florida statutes. Informal opinion to Armesto, September 18, 1979. Volunteer fire departments, on page 20, Attorney General Opinion 04-32 advised that boards of directors of volunteer fire departments providing services to counties with county-funded equipment are subject to the Sunshine Law. Compare Attorney General Opinion 00-08, Schwartzman versus Merritt Island Volunteer Fire Department, 352 Southern 2nd, 1230, Florida 4th District Court of Appeal, 1977 cert. Denied 358 Southern 2nd, 132, Florida 1978, found a private nonprofit volunteer fire department an agency for Public Records Act purposes due to its public function and funding. Finally, we address a staff member or public official also serving as member of public board on page 20. If staff members or public officials also serve on public boards, discussions among those board members about foreseeable board matters must be held in the sunshine. For example, Attorney General Opinion 93-41 concluded that communications between a sheriff and a state attorney as members of a county criminal justice commission would be subject to the Sunshine Law if discussing foreseeable commission matters. Compare Attorney General Opinion 11-04, which notes that if the state attorney and sheriff appoint individuals to serve on the commission in their place, their communications are not subject to the Sunshine Law. See now Section 286.01.141, Florida Statutes, 2013, which creates a Sunshine Law exemption for portions of Criminal Justice Commission meetings discussing active criminal intelligence or investigative information if public disclosure is made at a public meeting. However, the Sunshine Law applies only to discussions of matters that may foreseeably come before the board. For example, the Sunshine Law would not apply to meetings between a mayor and city commissioners, where the mayor performs city manager duties and commissioners serve as department heads if the meeting is solely for coordinating administrative matters not requiring formal city commission action. Attorney General Opinion 81-88, Accord Attorney General's Opinions 83-70 and 75-210. Similarly, the Sunshine Law would not apply to a school faculty meeting merely because two or more school advisory council members who are also faculty members attend, as long as they refrain from discussing matters that may come before the council. Informal opinions to Hughes, February 17, 1995, and to Boyd, March 14, 1994. This concludes our in-depth examination of the entities covered by the Sunshine Law, completing Part 1, Section A of the manual. Thanks for listening. Until next time, remember, the truth dies in the dark, so let's leave the light on.